And then after he finished his Oxnard work, he was president of this Nankai Nihonjin Byoin for about 8 years. Now, we're going to switch back to my grandfather. A story happened right about when he got his license. A woman with rambunctious boy said, "One day my eldest boy had an accident hitting his stomach." How can you do this? I don't know. He had an acute stomach ache. His stomach was swollen badly. We hurried him, from Gardena, to Dr. Tashiro's Little Tokyo Clinic. Dr. Tashiro diagnosed an acute hernia, immediately hospitalized at the Nankai Nihonjin Byoin. Operation was finished in 5 to 10 minutes. My husband was truly surprised with the speed with which Dr. Tashiro completed his surgery. For those of you who just had a doctor's visit, was that over in 10 to 15 minutes? No comment. 1913 Alien Land Law. Let's now talk about the legal climate leading up to the case where J. Marion Wright and family members were involved. This is before World War I. California, again, was alarmed at the torrent of little brown men coming into the state to take over farming. And they passed a law saying aliens ineligible for citizenship, which was all Asians, Chinese, Indian, Japanese, and Korean, could not own land or property. This land law, alien land law, had a lot of loopholes, however, and it was actually fairly doable to get land owned. World War I then happened, and Japan and the US were allies, so nothing happened during those years. But after World War I ended, the activists, what did we do in California? We put an initiative on the ballot. This passed by a landslide, and it closed all the loopholes. And the Japanese community here didn't take it lying down. They made a number of legal challenges to this law. They put a test case on naturalization, because if you could become naturalized, this law would no longer apply to you. And then they tried to challenge the law directly. However, our US Supreme Court uniformly rejected all these cases. Takaozawa in the US is a famous case in 1922. They said Japanese immigrants are not free white persons, therefore they don't qualify to become naturalized. In 1923, there were 3 alien land law test cases from the whole West Coast. They were all uniformly, well, the alien land laws were uniformly upheld by our US Supreme Court. So remember, this is the context. We have an unfriendly US Supreme Court, because this will figure later. Now, you could see on my third bullet, in 1918, these are Japanese farmers in California. There were about 8,000, and by 1929, there were 4,600. Almost declined by half. Had a huge impact. People who thought they had a livelihood had it taken away. The consul, Japanese consul Oyama Yujiro, said the land law decisions have dealt a severe blow to Japanese immigrants spiritually as well as materially. The sense of despair it aroused is hard to imagine. But that was not the end. Congress got into the act in the following year. 1924 passed the Immigration Act of 1924. In your history books, this is a complicated law. It had very restrictive limits for Southern and Eastern Europeans. It's favored Western and Northern Europeans. I think the quota was 2% of whatever amount you had in the country in 1850, some year like that. But it completely excluded all Asians. That was it for Japanese immigration, Chinese, Korean, Indian, all of them. In this community here, our community reacted by saying, we have been excluded, just like the Chinese. That happened in 1882. In Japan, they had mass demonstrations on July 1st, which is the day it went into force in 1924. They called it Kokujokubi, National Humiliation Day. Here in California, it was much more muted. They just knew they had been beaten down again. So remember that this is 1924. Now, we have this story in my grandfather's biography. when the Issei faced harsh economic realities in the aftermath of anti-Japanese legislation, some visitors from Japan showed much prejudice toward us as we struggled in poverty. They even ridiculed our poverty-stricken situation. Observing such behavior, Dr. Tashiro would take time out to explain to them the historical background of the anti-Japanese atmosphere in California. He was always quick to defend our honor. Japan was not supporting the community here either. Now, in the meantime, all these dispossessed farmers, they're moving to the cities. LA's population of Japanese Americans is growing to 23,000, and more physicians are attracted. There's 35. That was about half the total of Japanese American physicians in the state. So, the Turner Street Hospital, it's outgrown its capacity. Let's start a new one. So my grandfather and 4 other Japanese physicians applied to incorporate so they could raise funds from the community to build a hospital. Sounds pretty simple. California said no. So, this is the treaty that California said, nope, you can't do this. It seems to say that immigrants or in the other party's country, US people in Japan or Japanese people in the US, can generally do anything incident to or necessary for trade upon the same terms as native citizens. Seems to say that to me. But California said no. So, enter J. Marion Wright. What is the connection with the community? He was a USC Law School classmate and lifelong friend of Kashu Mainichi founder Fuji Issei. Fuji Issei referred my grandfather to Attorney Wright, and he had a track record in the community. In 1925, he had defended Mr. Tagami from the state at the state Supreme Court level. Let's show you that case here. This was involving what's called an onsen. This is in Palos Verdes Peninsula, those of you from Palos Verdes. White's Point. There used to be hot springs bubbling up there, and they built this nice onsen, which is a spa, sanitarium spa. You could soak in the hot waters. Unfortunately, the Long Beach earthquake dried up these hot springs. Otherwise, you'd still be there now. So basically, what this case established at the state Supreme Court level was that the state was saying a health facility is not a commercial venture covered by the treaty, but our own state Supreme Court said, no, yes it is, it's a business. It qualifies. So that was not the problem with my grandfather. The Tagami case was on the books saying, Issei can conduct a business of running a health facility, so what is the problem? Well, the problem now is they don't have the right to form a corporation to own land in California. That's what we're saying. Now, they brought it back to the state Supreme Court, and again, the state Supreme Court, in this case, ruled in the Issei's favor. So, what do you do if you're the Attorney General of California? Well, there's that friendly US Supreme Court. Why don't we take it there? So they appealed this to the Supreme Court, US Supreme Court. And this is where one of the people in the audience was on this trip. In April 1928, J. Marion Wright journeyed to Washington to represent the 5 physicians, accompanied by his wife and 2 daughters, ages 10 and almost 9. And before the 9 justices, Attorney Wright argued this was the first instance in which articles of incorporation had been denied a Japanese. Why is this the first time? The doctor's request was covered by the treaty rights. Treaties should be liberally interpreted. This was a precedent from the US Supreme Court itself. Therefore, the state should grant the doctor's request for articles of incorporation. Now, the justices did something interesting. When U.S. Webb, the Attorney General of California, got up, they sharply questioned him, and they cut him off before he finished his argument.